It's a little bit like church. Everybody knew when to get quiet at the right time. Good evening, everybody. My name is Jason Brickley. I'm the Director of Planning and Zoning. I want to take a moment to thank everybody for coming out tonight. This is a vital part of this process. This is meant to be a conversation about the Agricultural Preservation Program here in Calvert County. In a little bit, Jennifer David's going to walk through a PowerPoint presentation to show you some of the proposed changes and how we got to now and what the next steps will be. But I wanted to take a moment again to emphasize that your participation in this is vital. You may also notice that our commissioners are not here tonight. That's intentional. This is part of that process. This is us getting feedback in an informal setting, although we're sitting up here, as a way to gather that input before we get to a more formal setting. We are here to provide that feedback to them. We have our county administrator here that will help relay that message as well. So this is intentional that they're not here. It's part of this process. It's part of where we're at in that process. So I just wanted to point that out before we got started. The goal of this meeting is to provide a space for our residents to express those ideas, needs, and experiences as part of this program. And while this meeting is once again not a formal meeting, we do ask when we get to the question and answer part to try to be respectful of each other's time. We mentioned in here a 2-minute time for comments and questions. We're not keeping time. I don't think we're keeping time, but try to be respectful of that so that everybody's voice is heard. We also know that some of you may not be comfortable speaking out in a public setting like this, so we have time in the agenda for everybody to have time to meet one-on-one with us to have those questions. And even after tonight, it doesn't end tonight. So after tonight, if you've got questions, you've got, I think, Jen's cards out there. So, but feel free to call me. Feel free to call anybody that's up here tonight if you want to set up a meeting to walk through your concerns about the changes, your things that you like, things that you don't like, things that we may not have thought of as part of this dialogue and how it continues after tonight. So this is really just kind of kicking off some of that public feedback process. So if you don't get time to speak tonight and you'd rather set up a meeting with one of us, please make it happen, and we will make it happen. With that, I do want to recognize some individuals tonight. Once again, my name is Jason Brinkley. I'm the Director of Planning and Zoning. We do have Linda Turner, our County Administrator, who's also here. Just to my side here is Rachel O'Shea, who is the Deputy Director of Zoning. We also have Tamara Blake Wallace, who's the Deputy Director of Planning. The lady that was signing you in is Tay Harris, our Long Range Planner. We have Ron Marney up here. We have Summer Rowan. And we have Jennifer David, who's going to be presenting here in a minute. I'm going to turn it over to Summer to kind of walk through some etiquette mainly for the online participants. But once again, this is meant to be a conversation. Jen's going to present her slides, and then we'll open up the floor for that discussion. So once again, thank you for coming.
Good evening. My name is Summer, and I will be your Zoom moderator this evening. This meeting is being recorded on video and audio for record-keeping purposes. For those attending virtually via Zoom, please keep yourself muted to ensure no interruptions. If you are asked to speak and you are attending with audio only by telephone, you can mute and unmute using the phone's mute button or by pressing *6 on the keypad. If you are attending virtually with a computer or smart device, you can mute and unmute using the microphone button on the Zoom toolbar. When the floor is open for questions or comments, those attending in person will be asked to speak first, and then those attending virtually. If speaking, please identify yourself for the record first and then speak. If attending by telephone and you wish to ask a question or make a comment, please press *9 to raise your hand, and you will be called upon in turn at the appropriate time. If you are attending virtually and wish to ask a question or make a comment, raise your Zoom hand and you will be called upon. Please say your name every time you speak for the benefit of those calling in who cannot see you. Finally, please use the Zoom chat to indicate if there appear to be technical difficulties or if you cannot hear the meeting audio, and we will try to correct any issues. Please refrain from placing comments or questions in the Zoom chat, as not all in attendance at the public meeting can see those communications. And with that, I'll send it back over to Jen.
Good evening, everyone. I too want to, before I get started, I want to thank everyone for coming as well. It's great to see everyone. I hope that the presentation is informative. I will let you know off the top, it is, there's a lot of material. There's a lot to talk about, and so please be patient. Please hold your questions until the end of the presentation. We have a long question and answer time set aside just for that. I know it's hard when it's right here. I'm from New Jersey, so whatever comes in here sometimes goes out. But if you could do that, I would really appreciate it. And with that, I'll get started. So as Jason mentioned, tonight, the purpose of tonight's meeting is really to present the draft rules and regulations to the public and to discuss the proposed changes and provide a forum for questions and comments. The first thing I want to talk about is how does preservation fit in with the comprehensive plan. So Calvert County has focused on preserving its rural character since the first comprehensive plan was published in 1967. And a primary goal of the plan is to preserve the natural assets of Calvert County, including prime farmland, contiguous forests, and sensitive areas. Now, our program was created in 1978, and it's an important tool to help the county reach its goal of permanently preserving a minimum of 40,000 acres of land. If you're wondering, to date, over 32,600 acres have been preserved through various county, state, and federal land preservation programs, and the efforts of our preservation partners, land trusts, and private property owners, just like many of you. Just to break that down a little bit, the County Agricultural Preservation Program has, the program that we're discussing tonight has preserved 24,229 of those acres. The county TDR program works by preserving agricultural and forestry land by providing for the transfer of development rights within the county. Thank you. The program incentivizes preservation by allowing landowners to sell the development potential of their property to another party by agreeing to place restrictive covenants on their land. The TDR purchasers can then use those TDRs to attain a higher lot density on another property in specific receiving areas targeted for residential and commercial growth. Now, once an owner conveys or allocates TDRs from their APD, restrictive covenants are recorded that place use and development restrictions in perpetuity and cannot be removed. So regarding the status of the TDR program, so I think a lot of folks remember the recession in 2007, and at that time, after the housing bubble, participation in the program fell substantially. Private demand for TDRs plummeted, TDR prices sharply decreased, and county funding for purchases of TDRs was limited. The passage of the Maryland Sustainable Growth and Agricultural Preservation Act of 2012 further impacted the TDR demand. This is a law that has to do with septic systems and what areas of the county are targeted for growth or not targeted for growth. So at that time, the Agricultural Preservation Advisory Board completed a comprehensive review of the TDR program and recommended that the Board of County Commissioners place a moratorium on the acceptance of new applications for APD designation until revised criteria could be put in place, addressing the surplus of TDRs and reinvigorate the program. And the moratorium was approved by the Board of County Commissioners. It was effective in September of 2013 and remains in place today. So I want to go over the background for this project, how it got started, and go through how we got to where we are today. In 2020, the Transferable Development Rights Committee convened to review the county's program and make recommendations for improvements. And one of the recommendations that the committee had made was to lift the moratorium on the creation of new APDs. Once changes recommended by the Agricultural Preservation Advisory Board are adopted into the rules and regulations. They did make a series of recommendations trying to address the unbalanced oversupply of TDRs in the market, the volatility in the market leading to the undervaluation of TDRs for farmers, difficulty in completing private negotiations, and I think what people felt the most strongly about was there was a limited opportunity for additional land preservation due to the long-standing moratorium. Oops. So what has been accomplished since then, and what were the recommendations? So some of the recommendations from the TDR committee were to establish a TDR bank, to reinvigorate previous levels of land preservation program funding, to lift the moratorium, to establish a TDR bank managed by the county, to reinvigorate the level of land preservation program funding, and to expand rural legacy areas to include all priority preservation areas. So many of these recommendations have been implemented and they have been accomplished. So the corresponding accomplishments are that the TDR Reserve Banking Program was established in 2021. This banking program is a program by which the county will buy TDRs and then resell them back out to individuals and entities that need them for development in the county. Another accomplishment is that the funding from a portion of the recordation tax collected was reinstated in 2021 to support the county's agricultural land preservation programs. And an expansion of the rural legacy areas was completed in 2023. You may have seen on a previous slide, but I will reiterate that this is reopening the TDR program, lifting the moratorium for new opportunities for land preservation, having another tool in the toolbox for our preservation efforts. This is the last recommendation of the committee to be implemented. So just briefly on the topic of program administration. So the program is administered by these three groups. So the Board of County Commissioners and the Agricultural Preservation Advisory Board in cooperation with county staff. If you're not familiar, the Agricultural Preservation Advisory Board is a board that's mandated under state law. It's a volunteer board appointed by the county commissioners, comprised of 5 members and 1 alternate. And the primary responsibility of the Agricultural Preservation Advisory Board is to administer the state's preservation program, but we also administer the local TDR program. The role of the Ag Board is to promulgate the rules and regulations and develop procedures for the formation of agricultural preservation districts and the implementation of our overall program. So to discuss the rules and regulations, the TDR program rules and regulations were developed by the original county committee in 1978, and they have gone through several text amendments but have not had a comprehensive update since the program was initiated. And this is the main reason that we are doing this and why we are providing this update and this information. The program acts like a zoning district overlay, much like the critical area. And I want to emphasize that all participants are required to be in compliance with the Calvert County zoning ordinance as well as the rules and regulations of the program. Now, if you've been online, this is the front cover page of the current rules and regulations. It's available on our website. And this is the process. The Agricultural Preservation Advisory Board drafts the language. The Board of County Commissioners adopts via resolution, and then the Agricultural Preservation Advisory Board implements the program with the assistance of county staff. The most recent version was adopted in 2007 and later amended in 2017 and 2018. So for this update, these are our primary objectives. The primary objectives are to supersede all previous versions and apply a uniform set of regulations to all APDs. This was a recommendation that had come out of the TDR committee. To incorporate and codify policies, procedures, and decisions into a single cohesive document, to strengthen the program by addressing issues and challenges the program has faced, to provide clarification for consistent administration of the program, and to evaluate program eligibility criteria in preparation for lifting the moratorium. I also want to give you an idea of the timeline that we've been working with for this project. So as early as February 2020, staff had drafted a set of rules and regulations to supersede all previous versions and apply a single uniform set to all APDs. Now this initially was focused on addressing some challenges that the program had faced and including past policy decisions. And this initial draft was prepared by staff and the Agricultural Preservation Advisory Board. In the years 2021 to 2022, revisions continue as those other recommendations from the TDR committee I mentioned were pursued and implemented. Now in 2023, work begins on updates to the Calvert County zoning ordinance, which was recently adopted in February of this year. So we have a new zoning ordinance that we're working under. In 2024 to 2025, the draft rules and regulations is revised to be consistent with the Calvert County zoning ordinance that was adopted. In March of 2025, the document is approved by the APAB, and then in April and May, those proposed changes were taken to several stakeholder organizations to let them know about the changes and to garner feedback. On April 8th, we took this to the BOCC. We presented a summary of the changes and requested that we move forward with the public adoption process. And just last week, on August 20th, 2025, we made a very similar presentation to the Planning Commission. And then this evening is the information night where we're here to discuss with all of you. So again, the TDR committee made the recommendation that we take the rules and regulations and we make one set that's applicable to all APDs. And the reason for this is to make it, is to have it consistent and to have it easier to administer. So in reference to the zoning ordinance, per Article 4-2D, district standards of the current zoning ordinance, except as expressly provided in Section 7 of the Calvert County Agricultural Preservation Rules and Regulations pertaining to the withdrawal of a property or properties from the program, an agricultural preservation district shall be governed by the laws and regulations in effect at the time of its creation. This proposal, if adopted, would necessitate an amendment to the Calvert County zoning ordinance to remove or modify this provision. So what are some of the proposed changes to the rules and regulations? So this is a list of the overall changes, broad categories of those changes. We're looking to reorganize and simplify the overall document. This is going to make administration a lot easier. We're going to clarify processes and procedures, and this is going to make things more transparent for everyone, for the Ag Board and for the community. It's going to it includes necessary technical updates. These mostly relate to the criteria for designation as an APD once the program is reopened. So again, we're updating that eligibility criteria for APD designation. We're also updating eligibility criteria for PAR fund applications. The draft includes the new TDR, includes information about the new TDR reserve program, which I mentioned was implemented in 2021. So that is not in the current adopted document. It addresses allowable density in APDs. It codifies policies regarding the use of APDs for private and public events, and it limits amendments or modifications to agricultural preservation districts. So I'm going to go over some of these a little bit more in depth. Some of the program administration clarifications. The proposed rules and regulations incorporates past policy decisions and clarifies Agricultural Preservation Advisory Board processes and procedures in the following significant ways. It updates criteria and policies for the acceptance of an application for designation as an APD, specifies the conditions for amending an APD or withdrawing an APD, and outlines the procedures to be followed. It allows for the amendment or withdrawal of an APD only if it has not been permanently preserved and with certain conditions. And it defines when APDs are permanently preserved in perpetuity. So let's talk about that permanently preserved in perpetuity. So the definition of permanent preservation is the condition in which the land in an APD is preserved in perpetuity, and it is permanently preserved when all owners and parties having a proprietary interest in said property have voluntarily placed restrictive covenants on the land under the provisions of the Calvert County zoning ordinance and the rules and regulations. And the recordation of covenants is recorded by any act accounting for the use of TDRs. This includes, but is not limited to, subdivision of an APD, conveyance of TDRs, and the allocation of TDRs. And I should mention that the subdivision not only includes the creation of a new lot or parcel from within the APD, it also includes the creation of a lot around an existing dwelling. Let's now talk about the criteria for becoming an APD. Shown on this slide is a list of the minimum acreage criteria to be considered as an agricultural preservation district. Now, these criteria are going to change depending on whether the designated area, the area proposed to be an APD, is located inside the priority preservation area, the farm and forest district, the rural community district, or a rural legacy area. I know not everybody may be familiar with these areas. I've posted some maps in the back. If we have a chance later, please take a look at them. They will show you where some of these areas are. On my left is the priority preservation area map for the county, and on the right is a map of the rural legacy areas. Now, those areas closely align, but they are not exact. But if anyone is interested, I wanted to let you know that they were back there. It also is going to depend on if the property is contiguous with an existing permanently preserved property or not. So if you are contiguous to a preserved APD and you are located inside one of these areas, then you may be eligible if you can have APD with less than 50 acres with Agricultural Preservation Advisory Board approval. If you are located outside of these areas, then you would need to have a minimum of 25 acres or more with Ag Board approval. Now, if you are non-contiguous to a preserved APD, regardless of whether you are in one of these areas or not, the minimum acreage required to apply to become an APD would be 50 acres or more. also like to talk a little bit about some of the basic criteria that's in the rules and regulations. Much of this has been in the rules and regulations for many years. At least 75% of the total acreage of a proposed APD shall be suitable for cropland, managed forest land, or a combination of the two. And the land at the time of application must be of a type which will permit the continuation or initiation of a viable agricultural operation or forestry production. Also, 50% of the soils in the proposed APD must meet specific land capability classes to qualify. No more than 50% of an APD may be comprised of floodplain soils having specific soils classifications. These are generally hydric soils. And if you were applying into the program under forestry, at least 50% of the proposed area must be suitable for the production of timber of merchantable quality when seeking designation of the land as an APD.
And I know some of you may want this slideshow afterwards. We'll make sure it's available on the update page online.
Thank you. So I'd also like to mention that we are also looking at making sure that the program functions well and that we are accountable for the funding that we are spending, and that the program, that we maintain the integrity of the program. And as part of that, the application process is we are adding new requirements for the applicants to the program. So this is a list of information that you're going to want to be aware of if you are interested in applying for the program. First of all, I should mention the process for creating or joining an agricultural preservation district is entirely voluntary. This is not a mandatory program. This is not a zoning area. It's entirely voluntary. And the application process and required documentation is outlined in Section 7 and Section 8 of the draft. So please be aware that minimum documentation will include contact information for all owners of record of land proposed as an APD. In addition to current deeds and descriptions, a boundary survey for the property proposed for designation is going to be required. We're going to need complete title history of the property proposed for designation dating back to June 29th, 1967. We're going to need confirmation of or commitment to the development or implementation of a soil and water quality plan or forestry management plan as applicable. And then, of course, any maps, images, reports, and certifications that the Agricultural Preservation Board will require. Now, I know that, so for having a survey work done is, I want to mention at the time that also proposed within the regulation in the draft is a provision which in any given parcel will offer up to an additional $200 per TDR sold to applicants who are first-time sellers of TDRs that wish to recoup the survey cost associated with the initial boundary survey required for recording the APD. And this will be an additional incentive to remove the development options from the TDR market. So I know that can be a substantial outlay at the beginning of such a project or such a proposition or application, but we have thought of that, and we have put in a provision to allow for some ability to recoup some of those funds. So once an agricultural preservation district is recorded, that's the first step, then the TDRs are certified. An owner of an APD may apply to planning and zoning for the certification of TDRs by the BOCC. The TDRs run with the APD as a whole unless they are legally severed from the APD and allotted to an individual or property. And the computation for the allocation of TDRs is enumerated in Article 17-2 of the Calvert County Zoning Ordinance. The computation of TDRs is based on the net acreage of the property. So So it's something that you're gonna wanna be aware of. Now, what is net acreage? So the net acreage is the acreage of the property once the wetlands are deducted, the acres of wetlands are deducted from the property. And the boundaries of any wetlands are defined with the best available data. Going back to that, when I talked about those field surveys being required, those surveys will also show, that documentation will also show the net acreage of the property. 5 TDRs are deducted from each existing residence on the property. So for the March 2025 Calvert County zoning ordinance, again, there is 1 TDR credited per net acre of property. 5 TDRs are deducted for each residence on the property. 5 TDRs can be added for each 1 acre exception lot authorized but unused, but that is only till March 1st of 2027, after which time the eligibility in the zoning ordinance, the ability to create exception lots is null and void, and TDRs for exception lots will no longer be granted. Residential density in agricultural preservation districts. So once recorded, further development of all property within the APD is subject to the restrictions governed by the rules and regulations. The updated document ensures that the program functions as intended and to the level legally necessary by clarifying that density shall be applied by APD and not by parcel, specifying that primary residences buildable residential lots, and tenant houses count towards density. Clarifying that tenant houses are counted against density and the number of entitlements permitted as a result of changes to the Calvert County zoning ordinance. Per the ordinance, effective March 1st, 2025, 1 tenant house is permitted per lot or parcel, provided that the property has received an agricultural use assessment from the Maryland Department of Assessments and Taxation, and the tenant house counts towards the permitted density of the property. For further details, you can find them in section 12 of the draft under residential uses and the creation of residential building lots, additional dwellings, and non-residential lots or parcels. I want to be clear. The change from defining the language surrounding permissible density from per parcel to per APD is not a substantive change to the interpretation or intent of the program from its initiation, but rather a clarification of the existing policy. So per the currently adopted rules and regulations, tenant houses are not considered as residential lots. However, a tenant house can be used as one of the lots. Thus, tenant houses were not considered residential lots, but this provision has been in place and is being changed to be consistent with the recently adopted zoning ordinance. So here is the So here is the current text on the left and the consistent text with the zoning ordinance on the right. So in the current text, parcels having 75 acres or more, 3 lots in addition to the existing house. The consistent text would be APDs having 75 acres or more, 3 lots or dwellings in addition to the existing house. Parcels having at least 50 acres, less than 75 acres, and at least 50 acres would receive 2 lots in addition to the existing house in the current text, or in the consistent text with the zoning ordinance, 2 lots or dwellings. And between 25 and 50 acres, 1 lot. In the consistent text, 1 lot or dwelling in addition to the existing house. And parcels having 25 acres, no additional lots or dwellings are allowed. There are also updates in the ordinance, or in the draft rules and regulations, to program administration and the programs by which the county will purchase TDRs. So I think many people are familiar with the PAR Fund. The PAR Fund was established in 1992 and retires and permanently removes TDRs from the TDR market using county funds. Currently, only APD owners or original owners of the APD are eligible to apply. And the update will expand eligibility to include all TDR owners of record. Applications are ranked by a formula set by the rules and regulations for funding. In the TDR Reserve again was created in 2021 as a TDR bank. And the TDR Reserve allows citizens to buy and sell TDRs through county government. All TDR owners of record are eligible to apply. The update fully incorporates the reserve program into the rules and regulations and outlines policies and procedures relevant to its administration. So I want to talk about agritourism and permitted uses in APDs. Agritourism is a rapidly growing sector of the agribusiness market and complements traditional agricultural enterprises by providing for direct product sales and additional revenue to the operation. Agritourism was never specifically included in the rules and regulations. The update corrects this deficiency by incorporating those uses permitted by zoning and specifying the criteria by which public and private events may be approved by the APAB. Agritourism activities and associated uses such as public events are addressed in the zoning ordinance. A maximum of 12 public events per year are permitted on APDs with the approval of the Agricultural Preservation Advisory Board. So some of these agritourism criteria: public events and private assemblies on farmland are events held on a farm not related to farm activities. Such events may include, but are not limited to, performing arts and concerts. It is considered an agritourism use. Private events, rental facilities on farmland, are facilities or areas on farms that are available for rent for private events such as weddings, company picnics, or private parties, and is considered an agritourism use. For more information on these uses and for approval of these events, they are found in Section 13, Industrial and Commercial Uses of the draft. So for additional information on the draft and to see copies of the rules and regulations, please visit www.calvertcountymd.agricultural preservation update. I also want to mention that the public comment period is now open and written comments can be submitted to myself either by email or by mail to our address at 205 Main Street, Prince Frederick 20678.
Can you push forward to that contact slide on the slideshow?
Yes.
On the thing. The clicker. There we go.
So at this time, this concludes the presentation, and I would like to open the floor. We're going to have some time for a question and answer period on what we've presented and the rules and regulations. I hope everyone has had a chance to, if you haven't, please do go to the website, and I'm hoping that you have had a chance to look at the draft. We have plenty of staff here to answer questions. Again, as Jason said, this is a conversation. And we ask that everyone please be conscientious of everyone's time. Looks like we're doing great on time. So if anyone would like to come up to the microphone and speak, please do so. We're happy to answer any questions that you may have.
It's kind of a free-for-all, so just first come first. And once again, as I said at the beginning, if you don't feel comfortable speaking in front of a group, we'll be happy to meet with you one-on-one as time permits tonight or in a future meeting as well.
Good evening, Wilson Freeland, print shredder. I want to compliment you on the rule changes. I think they are going a long way in correcting some of the deficiencies and issues we've seen in the past. And I would support any new APDs coming in to have to apply by these rules. But what I cannot support is the 530 some odd APDs that currently exist being put under these rules. These are 530 APDs, but they're also 530 contracts that were signed back as far as 1978. And I can't think of any contract that has the ability to change once it's been signed off by both parties. So I would urge you to rethink eliminating that section of the current zoning ordinance, section 2(4)D, and the language that's in there, so we have some protection for the folks. And when I say folks, there may be multiple generations now that have come into ownership of these APDs that have no idea. You know, the folks that have not certified TDRs have the ability to get out. But the folks that are committed and have not used their allotments, some of these folks probably don't even know what they have. So to change that, I think is a slap in the face of the ag community. Thank you.
If you squeeze it,
Squeeze
yes.
on the side.
There.
There we go. We need it for midget size, so. Thank you very much for taking the time to listen to the ag community. I commend every single one of you for doing this. I am Kathy Cosgrove. I am the president of the Calvert County Farm Bureau, and I agree completely with what Wilson said. And the changes, I feel like if this is something that you are going to enforce, they can be less restrictive, but they cannot be more restrictive on contracts that are already sold, that have already been signed. And the thought of this to make it easier for planning and zoning, or to make this easier, it does not hold water in my book. It will not work. Farmers that preserve their land almost 50 years ago, their thought process on this, from my understanding, talking to other farmers, was to prevent I think it was Bob Kane at the time, from turning their farmland, from their farmland and getting sold and growing houses. That was the purpose. That was almost 50 years ago. They were not taking into account the future generations. They took into account maybe their kids, but now we have grandkids. We have great-grandkids from the people that signed these documents that may want to come back to the farm. So we need to also support generational farming. So our thought process, instead of taking away lots and taking away the value of the land, we need to start thinking about how can we keep generations on this farm? How can we keep people wanting to come back to the farm to continue farming? Farmers are a dying breed, and we need to keep the young generation interested, and we need to give them a place to want to build their family farm. And Calvert County is definitely the place to want to do that. We need to make sure it's viable for them. I'm sure you're gonna hear a lot more about, I think my time's up. I'll put it that way, but thank you for listening.
I
Thank
would
you.
like to take a little few minutes to respond to your questions, because there may
Yes.
be some things that I need to address, and anybody that cares to chip in, feel free to help me. So, absolutely, as Wilson mentioned, the Ag Board worked diligently through several staff members to make sure that this review has been comprehensive. And yes, we want to make it easier, but we're not making it easier just for us, and that's not the sole reason. We want to make sure that we're preserving the integrity of the program for future generations. So I take very much to heart what you're saying about future generations, because I think that's so important, and I think that's why we're so passionate about making sure that these rules, these updates are clarifying, that they provide transparency, that they enumerate our policies and our procedures in a way that is beneficial for everyone. And the other thing that I want to make sure that we're clear is that the density of the APDs is 1 dwelling per 25 acres. And that's what the zoning ordinance, the changes that have been in the zoning ordinance have done. So they have, with the changes made to the tenant houses, we're ensuring that, as I mentioned in the presentation, that we are being legally consistent. So I just want to put that out there.
If I can add to that on the tenant houses, once that change was made in the zoning ordinance, where you have two regulations that conflict, more restrictive shall apply. So that change, this is just to make the text match. That change is already come into effect through the zoning ordinance process. It's not something that this document or staff are seeking through this avenue or this process. It's simply to make it consistent.
Thank you.
You're welcome.
Good evening, everyone. I'm going to date myself a little bit here. I was 50 years ago part of developing this program, and
we're
I believe
grateful.
in agriculture preservation.
Susie, we know who you are, but can you tell us who you are?
Sorry, I may not want to put my name to it. It's Susie Hanswells.
You can whisper it.
Is my name. And I compliment you for wanting to do this. Every regulation ought to be reviewed at some point. And after 50 years, it needs a review to make sure everything is consistent. But what we did is we set up a program for prime agricultural and forest land preservation, not rural development. And unfortunately, there have been times where an ag preservation district with all its lots and all its TDRs and everything actually has been valued greater than for development. And now with the Tier 4, it still gives the agriculture preservation districts a little bit of an edge as to what they can and cannot do. Some of the things that I wanted to address were more specific than what Wilson. I do agree with Wilson that the county did sign a contract. I will say, in addition to that, if we can't get if we're at an impasse in this, that 2-year grace period should be given to everyone that is in the program in order to do what they need to do before you enforce these regulations. So I think 2 years is reasonable in one spot for certification of rights without including some of the entitled lots. You've given 1 year, and then for the, there's another one that you gave 2 years to use those exception lots. So I think that should be consistent, and I think 2 years is something that it would take you that long to get your land surveyed and get everything done in process. So I would say if you can't get that agreement, that we at least have a grace period, that everybody that's in an APD has the chance to get what they currently can get, at least for 2 years. There's another one where you have the Board of County Commissioners is taking over the approval of an ag preservation district, and I vehemently disagree with this. The Agriculture Preservation Board has the expertise and is not swayed by political opinion normally. But it's very important that the Ag Board has that privilege and not be taken away from them. And I understand it could be a legal issue, that if the county commissioners is conducting this program, that they should be allowed to have the right to approve or disapprove. I've known a lot of county commissioners over my time, and not all of them have the expertise to approve an ag preservation district by a long shot. The other thing I would like to say, that in the location of your lots, if you're taking away tenant houses, then the landowner should have the right of saying where they want their lots to go. A lot of us, the tenant houses were included in the original because of the tobacco industry, which a lot of us had tenant houses on our property. So that was allowed. And if you're going to make that tenant house one of our lots, a lot of these are not positioned on the farm in an area that wouldn't have an impact on the farming operation negatively. So there are different things like that you all need to address. And we definitely need to have a review of the regulations, not at a designated time period, but when things are developing in Calvert County that we need to change a regulation or change a word. So we need to be able to go back and do that, but not to take the rights away that you've already granted. So I appreciate that, and thank you.
Thank you.
Evening.
Good evening.
Paige Wyra from Solomon's. I was here at the last meeting, and one of the things that was omitted from the presentation about the events that preceded this was the fact that the Planning Commission voted the other night to reject, and in fact found that the amendment to make the ordinance retroactive was not in compliance with the comprehensive plan, and they declined to recommend that change for approval by the county commissioners. And that really, from my perspective, should have been in the presentation to give this group a full sense of what happened. And let me give you another example of a potential problem with making it retroactive. You want to make net acreage determinative of the number of TDRs a piece of property gets when it goes into the program. If you make that retroactive, and it wasn't net acreage when a property 50 years ago got put in, are you going to reduce the number of TDRs that these people have for sale?
I can answer that. That is not retroactive.
The whole ordinance is retroactive if you remove the provision which says that the rules that apply are the ones that are in effect at the time that the this ordinance is adopted. So that's an inaccurate statement. I would also tell you that from the standpoint of using conformity with current changes in the zoning ordinance as an excuse to make this retroactive and take away property rights is no legal excuse at all. It constitutes a taking, and the county will open itself up to a massive number of lawsuits if you go forward with making it retroactive. Thank you very much.
Thank you.
If I may address that, again, the TDR certification it's inaccurate to say that is retroactive, just as, so let's say you have a developed APD and it's already at max density and it has its tenant houses. The county isn't going to then in turn go behind and say you have to remove them. We're not going to take your TDRs from you. We're not going to take your dwellings from you. You can't do that. In that, you are accurate. It's what we refer to in anything else with zoning. It's legally non-conforming. The legally non-conforming status is what you would have. We're not going to rip your houses out. We're not going to take TDRs from you that have already been certified. That's not going to happen. That's inaccurate.
The legally conforming argument does not apply to the reformation of a contract that dates back 30 or 40 years. So that statement is inaccurate because there are limitations that you can put on grandfathering and so forth. So that your statements are just not accurate from a legal perspective.
Well, we've reviewed this with our county attorney. I'll defer to him to address that at a later time. Thank you.
Good evening, I'm Thomas Briscoe from St. Leonard. What Wilson said, I had something written, but what Wilson said, Purdue what I said, what I wanted to say. As far as the tenant houses, I feel that you want to keep Calvert County in agriculture and keep it going. To tenant house away from you that can help agriculture in different ways, it's not right to take that lot away from you, to count against your density. And then also, I'm not stepping on Susie when I make this comment, but a 2-year grace period is nowhere near enough time. You have generations that are far beyond us right now that don't know what you're going to do, whether it's financial reasons, whether it's family that's gone away and wants to come back in 10 years or something like that. I mean, you just cannot change the old rules. I signed a contract, and a lot of other people in this room signed a contract back before 2013. They should abide by that contract that they signed. Thank you.
Thank you.
All right, my name is Ben Ridgely from Prince Frederick. Most people in here remember my grandfather and my father. I agree with everything everybody said so far, but I'll speak a little bit to the other side of things. I'm trying to get into this program. I'm not made of money. A survey for a 250-acre farm is not cheap. Am I just supposed to pull that out of my pocket and front that for forever? I heard your $200 thing. That's not going to touch it. The COA is years behind, and they're just going to keep gouging me. How is anybody supposed to get into this? I already bought this farm from my family. They wanted to sell it. I'm keeping it the best I can, and everybody's coming at me for money. Everybody. So just to get into this program, I got to get this place surveyed. That's craziness.
I can touch on that a little bit more if you like.
Yeah, please do.
Yeah. So it's not just $200, it's an additional $200 per TDR up to the full cost. So you would get, if in that first par sale, if you sell enough TDRs, you will recoup the full cost of the survey. That's the intent. It's not just $200, it's an additional $200 per TDR. And again, none of this is set in stone. That's the entire point for these meetings, so that we can look at and evaluate different things. None of this is a done deal.
Right. And so I hear what you're saying, but let's do a little fictitious math. I got 257 acres. Let's say I got 200 TDRs. I sell them all, that's $40,000. I'd have to sell every single TDR on that farm in order to even get close to what this survey is going to cost. It's going to be $40,000 minimum. I don't think you're thinking about this thoroughly. And then COA is already years behind. What's going to happen when everybody tries to get in this program?
So can I ask?
You're going to have 100 people go to COA and say, I need a survey of a 250-acre farm. That's going to be years.
Can I ask you a question?
Yes, sir.
And this is, I'm truly want to know the answer to this. If you don't rely on a survey, how can you make sure there's an accurate number, a total of acres? How can you accurately determine that? Because I'm not sure that we want to trust SDAT.
You're taxing me on an accurate number of acres right now.
Do we trust that number?
I mean, are you not? You say I have 257 acres on the deed right now.
I think we have shown that that number is not always consistent.
Yeah, but it's not. Yeah.
I was going to, I
There's
wanted to
Because
thank
I'm-
the gentleman.
There's aerial GPS, there's all kind of stuff that you can say. I mean, it doesn't take a rocket science. You can go on Google Earth and measure these measurements. Now, soil quality, stuff like that, sure, send somebody out. Send somebody out. But a survey is gonna be $50,000 probably. And it's gonna take me 3 years to get it before I can even get into the program to try to recoup my money. So this survey stuff, it's really gonna gum things up for the new people.
It's
That's
going to
all
be
I'm saying.
difficult. I do want to mention, I will piggyback that I also work with several other state programs, and if it's any comfort, they all require a survey that is
It's not
accurate. I know it's no comfort, but I don't want you to think we're out of the norm. So they want to make sure that and that's the whole point, is to make sure that we have accurate acreage. I can tell you, many times we have to re-record APDs when they come in for, a new dwelling unit, or well, mostly for subdivision. When they come in for subdivisions, there have been occasions where we have found APDs have more or less acreage than what was originally recorded years ago from the old deeds. So it does happen. And again, going back to the concept of the integrity of the program, that's another reason that we have put that in there.
People aren't gonna be able to afford this out of pocket, just to get into your program. You're making it off limits for half the people with farms, right off the top.
I really appreciate your comments, but I did want to take the opportunity to explain a little bit more.
Yeah, the tax bill comes rather than survey.
Hello, my name is Jerry Pitcher. I live in St. Leonard, and I own one of the properties that are in preservation. I want to start off by saying the contract that was signed is no different than if I were to sell you my home. And 10 years later, I decide I want the house back. So what do we do with the contract? We tear it up like you guys want to try to do now? That's not gonna work. That's my opinion, and I think a lot of other people's opinion that's here. That's one item. The second item is the 2 years that Ms. Wells spoke about a grace period. That's nowhere near close. I applied for a permit for one house on my farm, and it took me 3 years. 3 years to get that permit. And Mr. Marty,
I remember.
I know you remember. And I'm gonna refresh your memory on something else. The person that was in your position in 2017 explained to me that I would not receive a house permit unless I removed my tenant house. So the statement you made earlier is not 100% correct. That
I can answer that though. That's because you were using the density from that tenant house to get the new house. So you couldn't have both at the same time. That was her concern, and that's what
Well,
we're getting at with that.
I after I bought the farm that was in it was a part of the program, I signed paperwork agreeing to the contract that was there from the start. So I knew what the contract was. I bought the same day that I bought the farm 5 TDRs from my attorney. So I had no intentions of using the tenant house density toward where I was gonna put my main house. If I were, why would I buy 5 TDRs?
I'll be honest, I'd have to go back to the permit file to see what happened then, because
like-
that's what I recall was that I thought they were applying it towards that new dwelling. Is that inaccurate?
Yes, I encourage you to look that up, because I wouldn't have bought 5 TDRs if I could, done it any other way.
Yeah, because you can always do that. You can always do some horse trading in terms of the TDRs and the dwellings as long as you don't go above the maximum density.
I
That
underst-
happens all the time.
I understand that, but there's a lot of things going on that are gonna nip you in the heel, because it's all coming to the top of the table. So my biggest thing is, you guys can't change the contract. You just can't do it unless you're ready to tighten your bootstraps up and go to Annapolis, because it's a breach of contract. So it's concerning, and it's affecting not only the people that own the property now, but it's making it very difficult to be able to leave your kids a farm, or even encourage them to be a part of the agricultural community. It's a uphill battle, and I don't think the planning and zoning doesn't have the right to have legal action to revoke a contract, a binding contract. So that's my concerns, and I hope you guys really think about, everybody's concerns here, because 500 and some people that own ag properties, I wouldn't want 500 and plus people coming after me. Thank you for your time and your effort.
Thanks, sir.
Matt Tedmer, Port Republic. I have a few concerns about that share with the room. One question that I have for you all is, have you reviewed how it compares to the Rural Legacy Program? I see some inconsistencies in the room, especially on the map, that doesn't delineate the Calvert Creeks correctly. I had a binding draft contract with the Rural Legacy Program. That was to be recorded as a deed. And if you make these kind of changes, and I understand it's a different program, but that's a legal binding document that's recorded with the land. Who's gonna pay the recordation fees to re-record that? Also, then Rural Legacy will pay for the survey out of their pocket. That is something that they offer. It is also a third-party contract. My draft contract was with the Navy. The Navy was gonna be,
Recording stopped.
thank you.
Now you can speak freely. Yeah.
So if that gets recorded with the land in its perpetuity, who's gonna re-record that deed? Who's gonna re-record these contracts? Who's gonna be faced with that financial hardship? Farmers are also always faced with financial hardships. One other thing that I'd like to understand is, how does your program protect you from eminent domain? Because you have a corridor that you wanna protect on Route 4 and Route 231. One reason that I never went through with the contract is because I had to maintain so many woods, so many fields. And I've been faced, my generations before me have been faced with eminent domain. It's, here's $10,000 for that acre, or I'm taking it from the state. So how are you putting in these contracts in place and protecting the people that are trying to preserve the land to have the state come and take it from them?
I'm not sure you can contract around eminent domain.
So what good is the contract if you're preserving 257 acres or 100 acres and it's on Route 4? What's the point of the contract? I know through experience that these amendments are probably because somebody broke the rules, somebody wants to break the rules, trying to clean things up. But you've been working on this for 5 years and you want to implement it sometime soon, I'm assuming. What happened to a trial period so that you all can see all the challenges that come in, everything that you're faced with? Let's not talk about a grace period, let's talk about a trial run. Okay, these are the new regs. Keep approving stuff on the old regs, but document the inconsistencies and where there's problems. Implementing something too fast that has this harsh of a change is going to negatively affect a lot of people financially. At this time, because there's several inconsistencies in both programs, I have deferred to not sign up. But I want to keep my farm. It's my personal agenda to keep my farm. There's one other thing that I wanted to mention. A lot of people in here focus on tenant houses. Well, can you provide a list of violations for all the farms, for all the rules? Who's going to enforce it? You're here to enforce the tenant house portion and all that. There's nobody that can enforce all the rules that are in these contracts. So why are we writing rules that can't be enforced, that we don't have the manpower to enforce? Thank you.
Thank you.
Thank you very much.
No, I think we're good, right? Anybody else? We speak now, or you can speak with us individually. So I guess that's the easiest way to do it. Anybody else have?
We do have people online.
We do have
That's where I was
guests
about to
online.
turn to.
If anybody would like to speak, just go ahead and raise your hand. And for those of you on the telephone, it is *9.
Nobody online. And once again, staff's here to meet with people individually. We've still got some time to meet tonight, or if you want to set up a meeting with myself, Jen, Ron, or Rachel, feel free to do that. I'm going to turn it back over to Jen for some closing comments. Once again, I want to say I really, really do thank you for your comments, because it's good to get feedback from those that are living in the program.
So again, I want to thank everybody so very much for coming out tonight. It means a lot to us that there's this much interest. It means a lot to us and I know to everyone in this room, and I will even say to me personally how much and how deeply this community cares about agriculture. It means an awful lot to me, and I'm very proud to work for planning and zoning and to work for all of you. So I just want to say that. Again, your engagement and thoughtful questions are a vital part of this process. I hope this session has provided you with some clear information about our agricultural land preservation program and the changes that are being incorporated into the rules and regulations. We hope you leave with an understanding that the updates are needed to ensure proper governance of the program and to regulate the use and limited development of land designated as an APD to the level necessary for compliance with the zoning ordinance and the comprehensive plan, and to open additional opportunities for land preservation in Calvert County while maintaining the integrity of the program for future generations. I especially want to thank all of our staff that have made themselves available tonight and for their hard work in supporting this project, the county's commitment to land preservation, and myself. I want to encourage you to provide any written comment you may have. I know that we've gotten some really great comments tonight, and I appreciate every one of them. A lot of folks are listening. A lot of folks are probably thinking and digesting. If you have comments, please contact us. Please provide written comments as well if you wish. The public comment period will remain open through the close of business on Monday, September 29th, 2025. All comments received will be forwarded to the County Commissioners ahead of a public hearing scheduled for Tuesday, September 30th, 2024 at 10:30 in the morning in the Commissioners' hearing room at 175 Main Street, Prince Frederick. Again, public comments can be submitted to Jennifer David at calvertcountymaryland.gov, at the Department of Planning and Zoning at 205 Main Street, Prince Frederick, 20678. Any additional information regarding the program itself, the rules and regulations update project, and the adoption process is available on our website. If you have any questions after this evening, please visit it at www.calvertcountymd.gov/ag-preservation-update. Or you can contact myself or Summer Rowan or any of us here. Staff has set a time aside to stay till approximately 9:00 p.m. to speak with you. So you can grab any one of us to answer any questions that you may have. Again, thank you so very much for your support of land preservation in Calvert County.
Thank you, everybody.